Welcome to In the Courtroom and the Boardroom, Business Law and Litigation with Colleen McKnight.
Hello, and welcome to In the Courtroom and the Boardroom with Colleen McKnight. Colleen built her career in big law before founding McKnight Law PLLC to bring high-caliber legal strategy directly to businesses. She now helps clients protect what they've built, from operations and IP to internal systems and trade secrets. My name is Kevin Rosenquist, and today, that's exactly what we're going to be talking about: how to spot trade secret theft and what to do before it turns into a lawsuit. Colleen, good to see you.
It's good to see you too, Kevin.
All right, so this is an interesting one: trade secret theft. So what legally counts as a trade secret under Texas or federal law?
That is such a great question. Like a lot of things in the law, it somewhat depends, but the broad definition is that it is an information, a system, a process, or a method that is not publicly or widely known and that provides value.
Okay. Now, I've heard about this stuff before, and things like KFC's recipe, right? That kind of stuff.
Right.
McDonald's special sauce or whatever. Those things that they keep really, really like tight knit. That's a trade secret.
That's exactly right. So Coca-Cola can't go out and get a patent on its recipe, right? You can't patent a recipe. So they, for more than 100 years, have had to keep that recipe kept very, very safe as a trade secret, because once it's out, and I can start creating a Coca-Cola, #2, and selling it on the market for less than they charge, and undercut them in the market.
Mm-hmm. Colleen Cola.
That's exactly right. Only if I got it by legal means.
Right. Of course. It's kind of crazy to think that no one's reverse engineered that by now, right?
And I think other people have tried. I personally am a lover of Coke Classic. I don't think anything comes close to it.
I 100% agree with you.
Yeah, it's a treat, but it is, Pepsi can't touch it, RC Cola, all the generics.
Yeah.
Yeah, it's one of those things. And maybe you think, as a business owner, I don't have trade secrets, right? But some of these processes that we're talking about are the way you keep your client list, right? You have it in a way that adds value, and you've figured that out. You've got details that you've collected from the time that you've known your clients. And if somebody took it with them, they could use it in a way that would undercut you in the market. Sometimes it's, the way that you process data. Sometimes, with a lot of clients now, it's the way that they use their data to provide efficient services to clients, right? And so the question is, first, did you treat it like a trade secret? Did you protect it? And second, how did the person get it, right? Did they just come upon it on their own way? Did they reverse engineer it just by tasting Coke in their kitchen? Because that's fair. But if they worked for you and they took the recipe with them, that's theft. The law recognizes it as theft, and they're not going to allow them to take it without recourse.
In your experience, how do businesses kind of find out that trade secrets have been stolen?
A couple of different ways. Often an employee quits and goes to work for a competitor, and then that competitor suddenly, very quickly, is able to compete in a way they couldn't before.
Right.
Sometimes when the employee leaves, they'll run forensics on their computers or their devices, and they say, hey, why did John have a bunch of big flash drives plugged into his computer the day that he left? Or why did Susie email her Gmail account everyone's W-2 the day that she left, right? And so doing those checks when employees leave can be really helpful. Obviously, at that point, the cat's a bit out of the bag.
Right.
Some of my clients know their trade secrets are the key to the kingdom, right? They have to protect that code. They have to protect the way that they do it. And so they're monitoring employees throughout. And if they see something like that, they come and make them delete it and sign an affidavit. A lot of times you've got 1 or 2 level authentication, right? Where you're saying you have to have a password to get to this information. And if I find out it was hacked, then I know those trade secrets are missing.
Mm-hmm.
It's not, ever quite as easy as my computer has been stolen or other traditional thefts. But oftentimes the clients will know from doing their own searches on the back end that something has gone missing and it's potentially going to be used against them.
So when it comes to a trade secret, this is something that you actually file for, correct?
It's not.
It's
There
not.
is no registry of trade secrets. No, because in
Oh,
that instance, you would have to give it away, right? This is not a trademark like, hey, McKnight Law is what I'm using to practice. I'm building that brand. It's not a copyright. It's much more fluid and unique to you. And so proving that it wasn't in the public sphere, it wasn't generally known, is always going to be part of the fight.
that's so interesting. So like, because obviously if somebody in an industry goes and works for somebody else in the same industry, they're going to use the knowledge that they've gained throughout their career to be a successful employee for the new company. How do you know if something's a trade secret or not?
Yeah, so part of it is, did you treat it like it was a trade secret while the person was working there? And oftentimes, what you'll see is a confidentiality agreement that you sign when you get employed that says, we're going to be handing you our trade secrets because you need them to do your job. If you're a salesperson, you need access to our sales list. You're going to have access to Salesforce and you're going to know what information we require you to track. Right. And we can't stop you from taking what's in your head and going somewhere. But oftentimes, this is why companies want a non compete. They want you to have to sit out for a year so the information grows stale and you can't go to a competitor and use it
Right.
against them.
Right.
Obviously, for employees trying to stay employed, taking my abilities that I've gained over however long and telling me I can't use them for a year is a problem. And so this is where you see that tension come into play. But if you ask your employees to sign those confidentiality agreements and you make clear what the trade secrets are, you're in a much better position to say, you don't get to go compete directly with me with the information you gained from working for me.
Yeah, because you can see it from both sides, right? Like, I mean, you can see, like, and I know there's been a lot of talk about that over the past few years about non-competes and how ironclad they are and all that. But you understand the business owner saying, "Hey, I spent all this time training this person, and then working with together for 10 years or whatever, and then they go to this other company, and then they're using what they learned for a competitor. But then at the same time, the person can say, "But this is what I'm good at. This is what I do for a living. They offered me this great salary. I got to do what's best for me and my family." So you can definitely see it both ways.
Absolutely. Absolutely. And so the law is trying to figure out that balance of
Right.
how do we allow these business owners to protect and still allow people the freedom of employment. And sometimes that means you have to work outside of a certain mile radius. Or if your sales territory was Texas, you just can't work in Texas, but go work in other places. We're seeing Congress put a lot of limits on doctors, right? Because sometimes those doctors' non competes were pretty broad. And so Congress is stepping in to say, hey, people should have access to the doctors that they want. And so we're going to make it a 5 mile radius, not an entire metroplex or an entire state that you can limit them from. And it is tricky because as somebody who's passionate about protecting what businesses are building, I do see that people put their blood, sweat, and tears in, and there's innovation in the way they're keeping information or in their systems. I'm on a case right now for an incredible AI product that helps people drill oil wells more efficiently and make sure that they're more successful. They had some employees leave, information went with those employees, and those employees went to a competitor, right? And so it is devastating for a company that had an edge in the market, that was a first mover and really did make that innovation or make that invention, and then have someone come along and completely, just steal their secrets.
Yeah.
And we have other means within the law to protect things. For example, if you did have something you could patent, part of that patent process is you do have to reveal it to the patent office. If they grant you the patent, it becomes public, but you get protection for a certain amount of time before it goes into the public sphere. And then we can fight someone who infringes upon that patent, right? Sometimes it's other kinds of IP protections. I copyrighted this, you're using it, I can fight you on that. But trade secrets are their own unique beast because they aren't filed, they aren't cataloged, they aren't out in the public sphere. And so it really is dependent upon you as a business owner to do everything in your power to protect it, so that when I have to come in and fight, I have all the tools that I need to say, this was a trade secret, we protected it, they're a thief, they've got unjust enrichment from using our information, and judge, you need to stop them and you need to make them pay us damages.
What should someone do? Like, what's a first step, legal step that someone should take if they suspect that one of their secrets has been stolen?
Yeah, so one of the first things you want to do is do those forensics on your data, because so often it is electronic at this point. So immediately getting that laptop back, getting that cell phone back from the employee, running those searches to understand, was there anything taken off of this computer? And this is something I hire experts for. I am not well versed in understanding when documents were transferred and what that transfer looks like. But our experts are, and they can say, okay, they put a flash drive in the day they knew they were getting fired and then they took it out, or they transferred this to their personal email on this day. And once I get access to their email, I can tell you, was it accessed? Was it modified? Was it transferred again? And so you really want, as a business owner who has those trade secrets, you want to have procedures in place so that you can do that check on the way out with your employees. You want to make sure at the beginning that you get those confidentiality agreements signed. And this is so important, Kevin, because when they sign that confidentiality agreement, you're not only getting theft of trade secrets, you're getting breach of contract. You're showing they knew this was a trade secret. They acknowledged that they couldn't take it. And by the way, now in Texas, if and when I win, I get my attorney's fees. So I'm going to say that it wasn't just that you walked out with my trade secret, but you also breached this contract with me. You know, there have been some instances of corporate espionage where someone tail ends someone into an office and is able to take a trade secret when they're not an employee and they're not under any contract. But most often when we're talking about trade secrets, we see it being someone who was granted access to that information, but then used it in a way that they weren't permitted to.
Yeah, the breach of contract helps. It shows it's malicious. It shows that there was malicious intent. Yeah, that makes sense. You know, we kind of touched on this before, but how do courts determine whether something really qualifies as a trade secret? Because, you know, like I said before, maybe someone doesn't, you know, if it's not applied for, maybe there's a little gray area there, but are there certain things the courts look for to determine this?
Absolutely. And as counsel and advocates for parties that are saying this is my trade secret, or the party arguing it isn't, part of our job is to put the information in front of the judge for them to make that determination. So if someone is saying, hey, you stole a trade secret, and my guy says, look, this is all over Reddit, this is everywhere, then part of our job is to pull that information, present it to the judge and say, this can't possibly be a trade secret, Your Honor, because there's nothing secret about it. It is out in the public sphere, it's known. Maybe I'm using it in a way other people aren't, but they don't get to claim that this was a secret. On the flip side of that, it's showing what's on Reddit is not actually what I have, and it's not what they're using. What they're using is the information they got from me that I had to give them to let them do their job, but then they took and they made money off of or got a job from giving this to my competitor. And so what you really have to do is say, this is a process, it's a method, it's a piece of information, it's not publicly known, and it has value. And so those are the things you're trying to show a judge to establish this is a trade secret. And as a company, knowing, hey, I have something kind of cool here, I'm doing this differently, setting yourself up with, you can't just get to this by going into the normal company system. There's always going to be a click-through agreement. there's always going to be a password that you need, is one way you're going to be able to show, hey, we treated this like it was a trade secret. We kept it protected.
Are they pretty much always civil cases, or can they be criminal as well?
There are criminal aspects of trade secrets. Most recently, what I've seen more and more is the DOJ coming in on a Computer Fraud and Abuse Act claim, which carries penalties. So if you're hacking into someone's system in order to get their trade secrets, or understand, sometimes I've seen it where, hey, I'm bidding on a project and my competitor was able to, through nefarious means, figure out what my bid was and undercut me, right? And if they did that through computers they should not have had access to, databases or cell phones they should not have had access to, you sometimes will see a criminal aspect of that. Or these corporate espionage cases, right, where somebody came in and actually stole it and never had any rights to it. More often we see them as civil cases. But if you're considering hacking into something, or even let's say you sold your company, but you know there's a back door to get into it electronically because you built it. And so you're just going to go through that back door. It didn't require any hacking. You know exactly where it is and you can pull information. We've seen the DOJ come down pretty hard on people in those circumstances and say, you don't get to use the computer to commit that kind of fraud, or you abuse the access that you had previously. Yeah. And it's, I mean, we're talking jail time, federal jail time. So, all's fair in love and war, but the law is going to come after you if you're doing something that is criminal.
What kind of tips or advice do you give businesses to prevent trade secret theft from happening in the first place?
Yeah, so first you want to have those agreements in place, right? If it's part of your handbook or something that people sign on for. And there's some details there that you're going to want a lawyer to help you with, because the law says I don't just get to get a confidentiality agreement without giving you something in return. Okay. And so oftentimes we tie a bit of compensation or a bonus or a severance to those things. But there are unique circumstances where you want to make sure that you didn't just have someone sign a confidentiality agreement and then later say, well, I didn't get anything in return for that, so it's not a valid agreement. You want to make sure that you are treating your trade secrets like they're trade secrets. If you're throwing it into every PowerPoint that you're presenting to potential investors or potential customers, I'm going to have a hard time arguing it was secret, right? So let's keep it out of the decks. Talk about it loosely, but don't present it to your investors or your potential clients or customers, because you're ruining its secret status at that point. And for, when employees leave, when you're issuing electronics, you need to have that process in place to run the forensics so that we know pretty quickly if we need to send a cease and desist or if we need to file for a TRO.
Yeah, that seems like a good one. I don't know that a lot of businesses, especially smaller businesses, would ever think to do that.
I know, and it's such a pain. And it's like, Colleen, I'm trying to run my business here. You really want me to have this all in place and always run those. But, your trade secret may be the thing that's going to give your business value and allow it to scale. And if it walks out with your first employee, you might have just cut your own legs out from under you.
Right. Absolutely. All right. Well, thanks for tuning into today's episode of In the Courtroom and the Boardroom. Remember, when it comes to trade secrets, prevention and speed are everything. If you think someone's been walking off with your ideas, or maybe you just want to get ahead of this, Colleen McKnight can definitely help. Learn more at mcknightlaw.us, and be sure to like, subscribe, and leave a review if you found this episode helpful. Colleen, it's always great chatting with you. Thanks so much.
Yeah, absolutely, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.